Good evening and welcome to the CLAT preparation series for 2023. In this particular lecture series, we were discussing about one of the most important aspects of CLAT preparation. We were talking about legal reasoning portion of CLAT 2023, one of the most eminent and most discussed and most perhaps critical topics for the preparation of CLAT examination. In this particular lecture series, we have uh, talked about the law of contracts. We have talked about the criminal law, and in from some previous videos, we have started with the Constitution of India. We have discussed about the preamble. We have discussed about the directive principles of state policy. We have discussed about how the state has limitations and what are the different organizations and authorities who are coming within the ambit of the state when defined under Article 12 of the Constitution of India. And from today onwards, we are going to discuss about the fundamental rights that has been provided to all the citizens of India by virtue of Part 3 of the Constitution. And the first and the foremost article that we are supposed to discuss in our current lecture series is about right to equality. So, right to equality, as you must have understood, that when we talk about right to equality, what we are saying is that we have to treat everybody equally. So now this particular sentence of to treat everybody equally perhaps creates a lot of confusion in the mind of the people and the residents and the citizens of the country. The reason being, there is a lot of confusion as to how we are going to ensure equality, whether a person who has been discriminated for quite a long period of time and he was not subjected to all the facilities that has been provided by the state, and now take him out from that particular discrimination and putting him forward with the race of the rest of the people is obviously something which will not be considered as equality, because he has suffered a lot, and there are less chances that he will be able to cope up with the pressures and the circumstances that is being there. So, in order to make sure that the equality that has been provided by the Constitution should be such that it favors both the person who have been oppressed and both those person also who have been not subjected to any sort of discrimination, both come hand in hand and they are able to cope up together. So for that, first we need to understand that where do we find mention of the word equality, and what is the reason we want that the state should work in such a manner that the equality should be maintained. As you already know that during our freedom struggle, we have suffered a lot of oppression and a lot of difficulties. So the constitution makers made sure that the equality that has to be ensured in this state should be such that it should be considered as a fundamental right. It can be politically enforceable. So you find mention the word equality in constitution perhaps only in two places. First, obviously, in our Article 14 to 18, where which the whole description of the equality is given, and the another one is in the preamble, where we see that the definition has talked about the right to equality in the form of status and opportunity. When we start with the preamble, it says, "We, the people of India," and then it ends at the state of 1949 that we adopted and enacted. And then during that particular preamble only, it has been mentioned that this equality shall be maintained of the status and of the opportunities that will be provided. So taking into consideration that particular equality of status and opportunity, there has to be some criteria how we are going to achieve that, because as we have studied that preamble is talking about what are the main objectives and what are the main goals of the Constitution of India, and why is it so has been incorporated. So in the same manner, Article 14 talks about two things that we need to understand. And I suppose the screen is visible to you all. Then we have, if we see the constitution under article 14, it has been mentioned that equality before the law. First we need to understand, there are certain things that we need to understand in this particular article. First we need to understand that what is rule of law, and then we'll try to understand that there are two things that has been mentioned under the article. If you can divide this particular article, the first is in the negative sense, that the state shall not deny to any person equality before the law. Okay. And then the equal protection of the laws within the territory of India. So if you divide the if we segregate and if we divide the article 14, there are two things that is mentioned. The first is no discrimination, and the second one being equal protection. There are two distinctions, and the first is about no discrimination, and the second one is talking about equal protection. So first we need to understand that this particularly is the negative sense of the article, and this one is the positive sense. Here it is the state, and we have understood what is state because state has been defined under article 12 of the constitution. So when we say state, so it means all the authorities which is coming within the ambit of article 12. So the state shall not deny to any citizens equality before the law. So it means that the citizens or any person shall not be denied equality before the law, which means that the law will not be biased towards anyone. So whether it be a rickshaw puller, whether be it a president, whether be it the governor, whether be it any minister or any bureaucrat, everybody is equal in the eyes of law. And that is what the first part of the Article 14 is talking about. So in order to understand that Article 14 in the first part talks about that everybody, whether be it a rickshaw puller, whether be it any citizen or any person, there shall not be any discrimination. First, we need to understand that what exactly is the rule of law. So, if we talk about rule of law as such, if we talk about the rule of law has been derived by the book of A.V. Dicey in the book of the Constitution of England. So from the Constitution of England, we have derived the principles of rule of law, which state that everybody is equal in the eyes of law, and the law should be such that there shouldn't be any discrimination on any grounds or any basis, and everybody is equal in the eyes of law. So this particular concept was given, and it ensures that all the laws are in generic sense are being treated equally, and everybody whomsoever is being exposed to these laws are not being discriminated on any of the grounds. So first is a more generic sense, where which the first portion, that is no discrimination, is actually generic in nature, and it applies to almost everyone, but this particularly is talking about the state responsibility of not discriminating anyone and treating everybody equal. Now, this is something which is obviously the responsibility of the state. But how the state is going to maintain the equal protection of the laws, that everybody will be treated equally and there will be equal protection of the laws within the territory of India, which means that there will be equality, and that equality will not be subject to any of the oppressions or discriminations. But now, before understanding this particular segment, the second portion of the Article 14, which talks about the equal protection of laws, we need to understand. And in order to understand, I'm giving you an example, and just let's try to analyze whether giving equality and by providing equal opportunities to the same sect of people or a general public as such, can it be a favorable ground or not. So let's take an example that there is a class, and there is a class of starting from class first and class 12th, and now the principal decides that we are going to take a random test of all the students starting from class first to class 12th, and that particularly will be of an examination of mathematics, and everybody will be given the same questions, and let's see who will be able to answer those particular questions. As you know, that it obviously will be easier for the higher grades, 11th class, 12th class, to answer those questions, because they have already well versed with the whole topics, they have understood it. But for the class 5th and class 6th, it will be perhaps a difficult task, because they are not well acquainted with the scenarios and what exactly are the problems, how to deal with those problems. So we see that by treating everybody equally and by providing equal set of questions, it becomes perhaps more. We can see that there is more inequality that we are providing. So there perhaps was the reason that there was a need. There was a need of classification. So in order to remove this inequality, there was a need of classification. Only after classifying the people into a different class and different sect, where which everybody within that particular class can be given equal opportunity. So the problem which I've just told you, that there are students comprising from class 1st to class 12, and everybody being given the same problem, then there are lesser chances that class 1st will be able to even solve the questions, and 12th class will be they will be very much competent to solve these questions, because they are well versed with the same. But this type of opportunity, by providing this type of opportunity, it is perhaps creating more inequality. So in order to make sure that the equality is maintained, and everybody, the whomsoever is the citizen, should be given equal opportunity, there was a reason, there was a need to do the classification of people, distinction of people on some criteria, so that equal opportunities can be given. So for that, what the constitution maker decided was that they are going to provide. So they are going to provide intelligible differentia. Now, what does intelligible differentia means? When we talk about intelligible differentia, what we are suggesting is that the classification of people in order to provide equality should be such that there should be a reasonable nexus. There should be a reasonable nexus, so that the end goal is to provide equality, can be achieved. So in order to make sure that the classification of people to provide equality should be such that everybody in the society, everyone in the society, gets advantage of it. We need to classify the citizens or the society in such a manner that everybody gets equal treatment. So in order to make sure that there is equal protection of laws for everyone, whether be it a rickshaw puller, whether be it a government servant, whether be it an actor, whether be it a woman, whether be it a child, everybody should be treated equally in the eyes of law. There was a need to classify the people, so that after the classification, we can see which particular class needs more protection and which particular class needs less protection. And in this manner, we talked about intelligible differentia. So what we are doing is, in order to make sure that everybody should be given equal opportunity, we are classifying people, and then according to their needs, we are providing them opportunities. We can take one more example for a better understanding. Let's take the example that there is a stadium, and there are three friends. Okay, I'm so sorry, but for my drawing is very bad. But for a better understanding, I'll try my level best. And all of them wish to see the match that is going on. But the problem is the whole stadium is fully occupied, and the only method that they can watch is by standing outside. But the problem is that number one is a very tall one, so he can obviously watch the match. Number two is of a middle height between number one and number three, and number three is obviously the shortest one. So if we talk about equality, if we talk about equality in a generic sense, if we would have provided equality to everybody, the hypothetical situation would be that if these three people want to see, and if they are not able to watch the match, what we can do is we can provide them an equal stool on which obviously they will stand and they will be able to watch the match. But the problem with this is that if we provide a stool to first person, it will be obviously very easy, because he was able to watch the match, and it is an extra advantage for him. And the third one, who was very short, is now okay, he's able to watch the match, but there is not enough visibility as compared to number one and number two because of his height. So this type of providing equality is perhaps still not able to relieve us from inequality. So that is why it is important, in order to make sure that these three people get equal opportunity and equal protection of laws within the territory of India, that there should be a reasonable classification, and according to that classification only, opportunity should be provided. So the another way forward where which an equality can be achieved would be, if this is the stadium and this is our spectator number one, this is our spectator number two, and this is our spectator number three. This person A being the tallest one, we provide them with the smallest stool. The middle one be provided with a medium stool, and the third one, who is the shortest, should be provided with the largest stool, so that each one of them are on the same height and same settings, so that they all are able to watch the match with equal opportunity. So that is how intelligible differentia and reasonable classification becomes an important aspect for everybody to understand, that this is how perhaps we are going to achieve equality. So in order to make sure that this type of classification is there, the state has to make sure that the people who have been given enough opportunity should be favored less, and those who have been oppressed and to whom the opportunity has still not been offered should be given more preference. And from this particular point onwards, we find mentions of reservation. Yes, you might have heard the word of reservation. So reservation comes up from this particular area, and it is not like that reservation is something which is bad or something which is good. This is something that we need to understand, that what exactly is the need of reservation. The reason, I just gave you an example, and if you can see, that particular example actually help us out in understanding that in the society there has been inequality from a quite long period of time, and in order to remove those inequality, it was perhaps necessary to mention to make sure that instead of just providing equal opportunities, we have to first segregate people and classify them in such a manner that that particular differentiation is helping us out to find out what exactly is the need of the society, and according to the needs and requirements we are providing opportunity. So that particular classification is actually very important whenever we are going to discuss about providing equality. So this particularly first one, rule of law, has been taken from England, and the second concept, the equal protection of law, it has been taken from America. So there are questions that will be there in your CLAT examination, where which you will be asked that from which portion of from which constitution we have taken the concept of rule of law. So you must be well acquainted that the rule of law has been taken from the English constitution, and the protection of laws, equal protection of laws, that has been mentioned in the second part of the article 14, has been taken from America. Now if we understand again, if we understand further, that when we talk about article 14 and we talk about equal protection, so now we understood that why there is a need of providing reasonable classification, because we have just seen that example, that if we provide equal opportunity to unequal people, then still there cannot be equal protection. So in order to make sure that this particular equal protection is there, we need to provide classification first, and then only we will be able to make sure that equal protection is given. Now the question that was put up in front of the constitution makers and the state was how we are going to provide that reasonable classification, how we are going to segregate, on what basis the segregation can be done. So for that we need to understand there are perhaps two things that helped us in understanding and what exactly is the test. And the test was given in the case of F.N. Balsara versus State of Bombay. In this particular case, we came to know that there should be an intelligible differentia, which I was just explaining you, intelligible differentia, and that particular this was given here, and that intelligible differentia should have the nexus with the end result. That what is the reason for classifying and differentiating, and on what grounds we are differentiating, and whether that there is a nexus between the providing that differentiation, and then on what grounds that differentiation is fine. That was given in the case of F.L. Valsara versus State of Bombay. So what the main criteria is, that whenever we need to classify, we need to see that we are classifying people who have the same sort of problems, and then based on those classification we are providing them all within this particular classification. All the people who are present there should now be treated equally, and equal opportunity should be given. It is not like that everybody be given equal opportunity, but rather the people who have been classified in this particular group, they will be given equal opportunity, and these other two groups will be will be obviously be given the same opportunity, but we are not going to provide equal opportunity to all the three groups, because again that particular problem of providing equality will be removed. So first we need to classify the people, and after classifying the people um, on the basis of their nexus and the opportunity that has been provided, the oppression that they have faced, after classifying them, then only the protection needs to be provided to them. So first thing that we have understood, that there needs to be an intelligible differentia, and then there should be a nexus, there should be a connection as to why we are going to provide this particular opportunity to this particular group and not other groups as such. So this is an important portion that we needed to understand, and I suppose that is very much clear to you guys, that what is the need of providing equal protection, first thing, and how we are going to provide equal protection, what is actually intelligible differentia, what exactly is reasonable classification, and how the state shall ensure that everybody shall be treated equally in the eyes of law. So this Article 14 becomes very important, because this particularly is providing us with two concepts. First is no discrimination by the state, and equal protection by the state, within the territory of India, from where we find mention of reservation. And reservation, I suppose it is an important concept that we are going to discuss in our future and upcoming lectures. But apart from that, we need to understand that this particular case, which provided us with the intelligible differentia and reasonable nexus, their intelligible differentia and reasonable nexus, this particularly was considered to be the old concept. This was considered to be an old concept, and then there was another case law, which was E.P. Royappa versus State of Tamil Nadu, which suggested that when we are classifying the people on different grounds in order to provide equality and equal opportunity, there is one more thing that we need to understand, that E.P. Royappa and the State of Tamil Nadu suggested that we have intelligible differentia, and this differentiation shall be done on the basis of the nexus as to what should be the end result. But apart from these 2 points that was there in FN Balsara, what was included by the EP Royappa versus State of Tamil Nadu case was the test of reasonableness. And from this concept onwards, we find the mention of the principles of natural justice. Now, when we talk about the principles of natural justice, this becomes a very important point, and that is how we are going to provide equal protection, that whenever we are going to classify, whenever we are going to provide any sort of opportunity, we need to make sure that there should be a classification of the people to whom those opportunities be given. So if we are talking, if we say that we are providing opportunities to women, if we are providing protection to children, and providing to opportunities to the oppressed class, it perhaps become a reasonable ground, because we are not talking of the society as such, because everybody was not treated equally from in the past. And in order to make sure that from now onwards we are coming and we are moving forward in such a direction that everybody is equal, first we need to remove that oppression that was there. We need to remove that obstacles which have caused the oppressed society and the people to suffer. And in order to make sure that they are also on the same footing in comparison to the rest of the public, it became a very important point, that first we need to provide them equality in such a manner that they can at least come on the same footing. Once they came on the same footing, then it will be easier for them to cope up with the society and then uplift. And that is how you find mention of one more thing, which is known as a creamy layer. So After this equality, after the incorporation of the Constitution of India and talking about equality, we have talked about reservation. But after providing reservation, it was observed that even after providing reservation after a certain period of time, there's going to be a conflict, because in future, when the person who have been given reservation will obviously be getting advantage, and the person who has not been given reservation will obviously be not able to cope up with the society. So the Supreme Court decided that there should be a concept of creamy layer, where which if there is a particular society who has been given opportunity, and by the use of those opportunity, by availing those opportunity, the person have been uplifted, so they comes into a layer which is which has been termed as a creamy layer, which means that by utilizing of those opportunities, by utilizing that the things that has been provided to the people, they are able to cope up, and now the reservation should not be provided to them. The reason being, they have cope up with the operations that they have faced. And that is perhaps the reason when we talk about people who have been availed the opportunity of reservation, they falls within the category of creamy layer. The example of could be the OBC category, and that OBC category, whomsoever has been provided opportunity and they are have a good amount of earning, they come fall within the ambit of creamy layer. And now from that point onwards, they cannot avail the reservation policies, and because they have been given equal opportunities and equal protection, and perhaps using those equal protection, they are now on the same footing like the rest of the public. So this is what the creamy layer is all about. And let's come back to understanding of the principles of natural justice, because that is also a very important concept whenever we're talking about the equality before law and equal protection of law. So I suppose we are clear with the rule of law. Rule of law is nothing but the statement of A.V. Dicey, which says that everybody shall be treated equally irrespective of anything. There shouldn't be any discrimination when there is any policy that has been framed for the betterment of the society, and it is a generic sense. It has been provided that the state shall make sure that there is no discrimination, and everybody is equally treated in the eyes of law. And when we talk about the second concept, which is talking about the equal protection of law, we are providing protection by first segregating people on the basis of their needs and requirements. And after classifying them, we are providing them opportunities and protection so that they can get upliftment. Those who require more attention, more protection should be given more protection, and those who require less protection should be given less protection. And obviously this is something which obviously is debatable from quite long period of time, that whether reservation should be there or not. But that is something that it is the view of the people and the view of the public. And maybe you might have a different opinion and the people have different opinion, but we are not actually involved in that particular opinion, because we have to understand the law, what the law says. Because in your examination, it is not your perspective who is going to help you out in mentioning and answering the question. It is perhaps what the law is and what the exact interpretation of law says. So law says that the state shall not deny to any person equality before the law, which means there is a concept of rule of law. The law is supreme, and the state shall make sure that uh, there is no equality, there is no discrimination, and everybody, whether be it a rickshaw puller, whether be it a fruit vendor, whether be it a seller, whether be it a merchant, whether be it a professor, whether be it a lawyer, whether be it a president, everybody is equal in the eyes of law. Okay. And the second one obviously is talking about the protection of law. From the protection of law, it came the concept of the principles of natural justice. So principles of natural justice is an important concept when you talk about right to equality. And also there will be article 15, 16, 17 and 18, which also takes mentions about principles of natural justice, and which says that principle of natural justice says that there should be a ground or reasonableness, and how to ensure reasonableness, we have to go through actually two grounds which is within the ambit of the principle of natural justice. First being audi ultram partem, which means right to be heard. So right to be heard means that whenever there is a decision that has been that has to be provided, the first we need to understand both the parties. We need to make take into consideration both the aspects, and then only we should be providing justice. We should be making sure that everybody is being treated equally. So this particularly concept of principles of natural justice has been incorporated under Article 14. So I suppose it is very much clear to you that Article 14 has been divided into two portions, and we have dealt with both the aspects. Now we need to understand that how the questions will be there put up in front of you, and you need to answer those questions. The first type of questions that will be put in front of you will be in regards to equality before the law. So when we talk about questions in relations to equality before the law, we need to understand that there will be a question which there will be a factual question in which you will be asked that there is a sect of people who has been discriminated on the basis of caste, color, creed, sex, etc. And what should be the responsibility of the state. As you know that under Article 14 we have talked about that the state shall not deny to any person equality before the law. We need to understand that when we talk about equality before the law, we are suggesting that everybody is equal, and whatsoever the discrimination is on the basis of caste, color, creed, etc. should not be there. So we have to remove that, and only based after removing it we can ensure that there is equality. And the second question, which is perhaps the most important one, is the equal protection. So you might get questions on the basis of that there is a sect of people who were given equal opportunity. And based on that equal opportunity, understand or analyze whether equality is ensured or not. Then you have to analyze, you have to understand the concept, you have to read the question very clearly, very after understanding that okay, this particular question demands this point, and see to it what are the laws, what exactly the law says, exactly the law suggests, and based on that you will be able to answer the question. So with this, Article 14 is completed. I suppose you people have been able to understand the concept, and now let's move forward with Article 15. Okay, so Article 15, which is talking about prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth. That has been mentioned under Article 15. First, we need to understand here that there is a misconception which says that if there is a discrimination on the basis of religion, race, caste, sex, or place of birth, then it is not equality. But then comes a question that we get reservation on the basis of caste. Then how is it not discriminating? Isn't it a question that In our previous article, we have studied that there shouldn't be any discrimination on the basis of these things. And if we are providing, if we talk about reservation, then isn't reservation discriminating? Majority of you might feel yes, it is discriminating, and I would not say that it is not, because discrimination is also of two types. First is negative discrimination, and another is positive discrimination. The Constitution rejects negative discrimination and supports positive discrimination. Now, what does positive discrimination and negative discrimination means? I would like to explain it to you. That if you are not providing somebody with the opportunity which they require or which is their need, then this is known as negative discrimination, which is not entertained by the Constitution. But if you are providing opportunities to those people who are in dire need and not providing opportunity who doesn't require those opportunities as such, and in order to make sure that the end result is that both the people who have been provided with the opportunity and who have not been provided with the opportunity come on the same platform or same footing, then that type of discrimination is known as positive discrimination. And that is why when we talk about reservation, when we talk about providing reservation for the betterment of the society, for the betterment of the people who have been oppressed, this particularly is known as positive discrimination. So cannot be discrimination solely on the basis of caste, color, creed, say place of birth, etc., that has been mentioned under Article 15. But if there is another ground along with the 5 things that has been mentioned, then discrimination is possible. Discrimination is possible. So for example, if there is a caste which was not given equal opportunity in terms of education, and based on this particular factor, if some caste is being provided reservation, then it shall not be considered as discrimination. I suppose the things is clear to you that only based on the 5 grounds we cannot discriminate, but along with these 5 grounds, if there is anything which is actually causing discrimination, if there is any other ground along with this ground, then discrimination is actually possible. So we need to understand in a very clearer manner that there must be a confusion there must be a confusion and the things that might be going on, because it is a new concept for you, that discrimination on only on those grounds. Okay, so when we talk about Article 15, the only thing that we need to retain is that only on the basis of these 5 grounds, first, second, third, fourth and fifth, there cannot be discrimination. That if we are talking about discrimination only on the basis of religion, then it is prohibited. Only on the basis of race, if somebody is not being allowed to enter into any particular area, premises, etc., then it is discrimination. But if there is another grounds along with these grounds, then it won't be considered as discrimination. So this is a concept that we need to understand. And the Article 15, if we talk about Article 15 as such, Article 15, in the first clause of Article 15, we find reference of that it is the state responsibility Article 15 subclause 1 talks about that it is perhaps the state responsibility. Article 15 subclause 1 talks about state responsibility, that the state shall not discriminate only on the basis of these 5 grounds. But if there is any other ground along with it, discrimination is possible. And Article 15 clause 2 provides the responsibility of the citizens that they shall not discriminate. So it is not only the duty of the state, but rather the duty of the citizens. So we have to make sure that we are not discriminating somebody on the basis of religion, caste, color, place of birth, etc. We are not stopping them from entering into places of public community. And you will find mention of use of wells also. If you will go to and you will read the Bear Act, you will come to know that it is not only public places, but eventually during our freedom struggle, during our past, there were people who were even not allowed to use the wells, the tanks, the areas which is of public in nature. They were not even allowed to use those areas, and that type of operation was there. But by virtue of incorporating Article 15, we made sure that not even the citizens should be allowed, and no person should be discriminated, and everybody should be given access. And here you need to understand one more important aspect, and which might be asked in your question, that what are the rights that has been provided only to the citizens. So Article 15, Article 16, Article 19, Article 29 and Article 30 are perhaps the only article which has been given to the citizens only. And this is a question that will be there, that might be asked to you in your question in your CLAT examination, that what are the grounds, or what are the different articles, or match the following, that within these articles only citizens are given opportunity and the citizens are given the rights, and it is not available to everybody. So after understanding that these are the different articles, Article 15, 16, 19, 29, 30, only these articles are provided to the citizens, and the rest of the articles are provided to everybody. So this is what we need to understand, what we need to get in our mind whenever we are going to attempt the question paper. Article 16, equality of opportunity in matters of employment. This article talks about opportunity in regards to employment. So this particularly provides that if there is a particular sector of the society who has not been given opportunity to represent them in a particular sort of employment, they will be given opportunity not only in getting the employment, but for appraisals within the employment. Appraisals within the employment means that promotions will be favored. This is Article 16. Article 15 we have covered, that we talk about prohibition. And Article 15, there are perhaps 6 clauses, but the chances of you being asked questions in regards to from all the 5 clauses, the chances are rare. All the 6 clauses, the chances are rare. But the important clauses are Clause 1, which talks about the state responsibility. Clause 2, which talks about the citizens' responsibility of not discriminating. Clause 3 suggests that This is state responsibility, this is citizen responsibility. Clause 3 obviously is not important for you. Clause 4 is talking about non-discrimination. And then you have clause 6, which has talked about economically weaker section, which has just been incorporated in our constitution by 103rd amendment. And that becomes an important point for you, that by the 103rd amendment, economically weaker section, reservation for economically weaker section has been talked about. And where it has been talked about? It has been talked about under Article 15. So this is something that you need to remember for your CLAT examination point of view. So we have discussed Article 15, Article 16, Article 14 also we have discussed. We have talked about reasonable classification. We talked about two cases that is important for your CLAT perspective that might be put forward in front of you for in order to check whether you have been acquainted by these concepts or not, these principles or not. And now let's move forward and focus towards Article 17 and 18. So Article 17 and 18 are not perhaps not very important for your CLAT perspective, with which it's talking about abolition of untouchability. So if somebody if somebody does such an act which it's amount to untouchability, then it is an offense, and the person has so nobody should practice the concept of untouchability that has been mentioned under Article 17. And then Article 18 talks about abolition of titles. Abolition of titles means that earlier we used to see Lord Curzon or Lord Miller. So these titles, sir, all these titles were abolished, and nobody is supposed to use the titles before their names in order to suggest superiority. And why is it? What is the reason for mentioning these things in Article 18? Because the end goal of all these articles, starting from Article 15 to Article 18, is to ensure that everybody is equal, and the right to equality is maintained within the whole nation. And that is why Article 14 to Article 18 takes a very much important portion of the Constitution, because they ensure that equality is maintained throughout the nation. With this, we have completed Article 14, right to equality, Article 15, which talks about discrimination, Article 16, which talks about providing opportunities in the matters of employment, Article 17, which talks about abolition of untouchability, and Article 18, which talks about abolition of titles. After completing this particular portion, we will now be focusing our minds towards Article 19, Article 20, 21, and then we will shift towards Article 29 and 30, which talks about non-discrimination and prohibition, and then we will talk about the constitutional remedies. Post completion of this, we will be moving forward towards what exactly is union, what exactly is the powers of the ministers, and then we will be discussing about the emergency provision and the amendment. These two the remaining concepts will be cleared in our upcoming next two lectures, and post completion of that lecture we will be completing our syllabus of the Constitution of India, and then we will be resorting towards the law of tort. With this, I would request you all again to be consistent with your practice. Don't stop practicing, because unless you have not practiced, it won't be favorable for you to understand the concepts. You will not be able to abide by the same, and that is why it is very much necessary for every CLAT aspirant, and I've been talking about it from almost all of my videos, that becomes a very important concept and learning, that whenever we are preparing for any sort of examination, it is 30% of the principles, 60% of your practice, and 10% of your luck that is going to help you in clear the examination. So kindly continuously do practice, solve previous year question papers, and obviously after the completion of our syllabus, we will be taking a mock test series, and we will be solving previous year question papers, so that we are well versed with the situations that we need to focus over. And after completion of that particular lecture series, after completion of the mock tests, we will ensure that all the CLAT aspirants who have been with us, who have pursued and who have understood the concepts with us, are able to get a good rank in the CLAT examination. And with this, I would like to thank you all for being present here. And one more thing I would like to tell you, that whenever we are talking about right to equality, and whenever you find mention of state throughout this lecture, so we need not get confused that whether we are talking about state as India or state as defined under Article 12. We have to understand that whenever we are talking about the fundamental rights, which has been mentioned under Article Part 3 of the Constitution, we are talking about the state that has been defined under Article 12. So Article 12 have defined what will be the state. The state will comprise of the president and the parliament. It will consist of the governor and the legislatures of the each states. It will comprise of the local authorities, and it will comprise of the other authorities. And we have discussed it in detail. What will be the local authorities? That has been mentioned in the Clause 3 of the General Clauses Act 1897, and then we've discussed numerous case laws, starting from Somnath versus state of Bengal. We have studied about the different cases. Ajay Hasia case we have discussed. We have discussed majority cases, which are important in order to understand what all are the other authorities. If I would like to show you here, we have studied University of Madras versus Shantabai, where we studied about jus generis. We studied about Ujjambai versus state of Uttar Pradesh, where this particularly of the same kind nature state has not been allowed. Then it was in the state of Electricity Board of Rajasthan, where the concept of jus generis was accepted, that the constitution created by the constitution of the state authority will be under the other concepts. Then we have already studied about the Sukhdev Singh versus Bhagat Ram case, which talked about the LIC, ONGC being the part of the other authorities within the ambit of state. Then when we studied about R.D. Shetty, which talked about the agency and the instrumentalities there, which provided that international airports are under the other authority within the state. Then we talked about Ajay Hasia versus Khalid Mujib, which provided us with the detailed test as to how to ensure that this particular authority is within the government control or not. We studied about that if they have entire shell capital, deep persuasive control, public importance, and monopoly, then it is within the ambit of state, other authorities. Then we talked about Pradeep Kumar Pishwa versus Indian Institute of Chemical Biology, which suggested that if that is of national interest within the meaning of the state, then it comes under other authorities. Then we talked about A.R. Antulya versus R.S. Nayak case, which provided that if the judiciary is working and if they are performing administrative functions, then they are considered as state, but when they are doing judicial functions, they are not considered as state within the ambit of Article 12. The other cases were, we studied about Chandra Mohan Khanna versus NCRT not being the state. We studied about Z Telefilms, which provided that the BCCI shall not be considered as state. Sanjay Bahal case has tells us that United Nations organizations not comes within the ambit of the state. Then we have Tekraj Vasanti versus Union of India, which perhaps an important case which told us about that the parliamentary studies, Institute of Parliamentary Studies does not provide us does not fall within the ambit of state. Then it was state of Som Prakash versus Union of India, which suggested that Bharat Petroleum Corporation is a state. Okay, then we have studied about Article 13. I suppose Article 13 is clear to you. And now we have also completed with Article 14, 15, 16, 17, and 18. We have completed the equality portion. We will be focusing towards the freedoms, the fundamental freedoms that has been given. We will talk about the protections that has been given to the offenders under Article 20, and then we will talk about Article 21 and Article 20, 29 and 30, because Article 22, 23, 24, 22 perhaps is important. We will discuss that, but in not in a detailed manner, that like the way we are discussing about Article 14 and 13 and 12 we have discussed, because perhaps you will not get questions from them, because the concepts are not very much there in totality. But when we talk about Article 20, it's a very important concept. We're talking about right to life and personal liberty. There are numerous cases that has been involved in that particular case, and accordingly, we will try to summarize within the next two lectures the whole constitution, and then we will be focusing our mind towards the law of torts. Okay, thank you so much, guys, for being patiently available here. I would request you again to kindly continue with your practice and try to analyze whatsoever we have studied. And if you have any sort of problems and you're not able to cope up what exactly is this particular article saying, I would strongly recommend you that you reread it again and again, only through bare acts. Because bare acts, once you are able to understand the bare act, once you are able to read the bare act, there will be no doubt and whatsoever that will be left in your mind. With that, I would thank you all for being present here. Let's meet in the next video. Till then, thank you so much, guys. Bye bye. Take care.